What is a patent? A patent is the right to prevent others from making, using, selling, offering from sale, or importing within the US what is covered by one or more claims of the patent for a limited time. We're going to break down the elements. The right of a patent is infringement of it would be a tort, meaning that it's not illegal in the sense of a criminal way to infringe on a patent, but if you have infringement, it would be the same as committing assault or negligence, and you could be entitled to injunctive relief or damage relief. Next, it's to prevent others, which would be the right to exclude, which is the ability to stop others. Next, it would have to be one of these five different making, using, selling, and then it would have to be within the US. It would have to fall under what the claims of the patents are for, and it's going to be from a limited amount of time. Time is measured now by 20 years from the earliest effective filing date, which began after June 8, 1995. However, before then, if you had a patent that was in force on June 8, 1995, it would be 20 years from the earliest filing date, or it would be 17 years from issue. And the 17 years from issue was the old way that they would see how long the patent would be in effect for. Next, we're going to take a look at the overview of the application process. There are three stages: the inventive stage, the prosecution stage, and the post-allowance enforcement stage. In the inventive stage, it begins with conception, where the person envisions a new or useful concept. Next, they're going to reduce it to practice, meaning they're going to create the inventions, actually producing the concept or idea. And you could have that in two ways, either actual reduction or constructive reduction. Actual construction is you actually build the invention or you perform the steps of the innovative process, or constructive reduction would be a description in such detail that it would enable one who's skilled in the art to make and use the invention. After that, you would file. The USPTO will review the application for completeness, and if there's a missing part, they would give you a notice of missing parts, which would be that you missed the requisite filing fee, a declaration of the inventors, or it was not filed in English, or they would send you a notice of omitted items if you forgot pages or you were missing drawings. And for both of these, you would get 2 months, and they're extendable time periods. Next, it's going to be the application is going to be forwarded to the patent examiner, and it's going to be examined on merits, and they're going to look at 35 USC, 37 CFR, and the MPEC. While during the review process, they're going to look for potential restriction requirements, meaning that if one patent is entitled to one invention. So if there are multiple inventions, they're going to restrict the inventor, and they're going to force them to elect, meaning to choose one of the inventions, and the non-elective patents can become divisional patents, and they would get the same effective filing date as long as they were co-pendency, and they would get the earlier filing date. And the applicant gets an extendable period of time to choose which of the elective applications they want to do, and the non-elective inventions would be could be pursued in a divisional application. Next, the examiner is going to search, and he's going to do a comprehensive search of the prior art of the elective invention. After that, they're going to issue a first official action, which would set forth each allowable aspect of the claimed invention and each deficiency. And by statute, the applicant's going to get 6 months to respond to the first official action. Usually, they'll only get 3 months, and they'll be allowed to automatically extend it. However, they're not going to be able to extend it past the statutory maximum 6 months. And in the response, the applicant must respond to each and every objection and rejection. And once the response is filed, the clock is going to stop, and it's going to go back to the USPTO, and they're going to be reviewing it, where the examiner will review the response. If it's satisfactory, the examiner is going to allow the application. If it's not resolved, they're going to issue a second official action, which is just the same as the first official action. Next, you could have a final action and a non-final action. A non-final action would be the same as a first official action, where you could respond to each objection and rejection. Or you could have a final action. There are special restrictions, and the applicant may not raise any new issues, which are actions requiring further search by the examiner, and the amendments are entered as a matter of right only if they reduce the issues for appeal or they adopt suggestions to resolve the objections or suggestions of the examiner. Next, you could have a final rejection, where if the examiner makes the same rejection for the second time, or new rejections are necessary by amendment by the applicant is going to get finally rejected. However, the applicant is going to be able to avoid this if they're going to try to persuade the examiner to withdraw the rejection without amending the claims. Amendments after the final rejection cannot add any new claims or make substantial changes to the existing claims. And after that, you're going to have the appeal, allowance, and abandonment, which we're going to get to in the next video, as well as what happens in the post-allowance enforcement stage.